This sends a message and also takes action to say, listen, as Christians, as people of faith, as just people in favor of human rights, abortion is a travesty, right? We shouldn't be, not only should we not be killing unborn children, but we shouldn't be funding any organization that's even involved in this practice. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering all good news, a ministerial exception case in the Ninth Circuit. Then we'll talk about the continued battle over the pro-life abortion pill reversal services being offered by an organization in Colorado. And we'll wrap up with more positive action from the governor of Oklahoma, who recently signed an executive order blocking all state funding to abortion providers. So with that, let's jump right in. There's a lot to cover. So in the Ninth Circuit, we just got a ruling from in a case called World Vision that Napa Legal has been watching for a while. And it has to do with the ministerial exception, which is a doctrine that comes from the First Amendment. So I'll do a little bit of backdrop before we actually talk about the World Vision decision. So the ministerial exception grants employers wide discretion when they're managing or interacting with employees in certain roles, if those employees are legally considered ministers. Now, it's always important to note here that minister has a different legal connotation than what we would typically think in our normal conversation, right? When you think of a minister, you typically think, if you're not a lawyer or involved in this world, you think of a priest, a pastor, a rabbi, an ordained minister, right? That's not necessarily what we're talking about. We'll get to that in a second. So, rooted in the First Amendment, the ministerial exception exempts religious organizations from most federal and state employment non-discrimination laws. That's where this most commonly comes up. When an organization is hiring, promoting, firing, or making other kinds of employment decisions related to individuals for jobs that fall under the ministerial exception. And the logic of this is it's not a choice, it's kind of a requirement of the law. The government doesn't have jurisdiction to interfere in doctrinal and religious matters internal to a religious organization, right? That's kind of one of our basic tenets in the religious liberty movement, and especially here at Napa Legal. So who a religious organization chooses as its ministers and how it hires, fires, and so on, those ministers, is not a question for secular courts. That's what the ministerial exemption is in a nutshell. In 2020, the Supreme Court broadened their interpretation of the exception, or at least started to flesh it out a little bit in a case called Our Lady of Guadalupe versus Morrissey, who a lot of our listeners are probably familiar with this case. Our Lady of Guadalupe ruled that the ministerial exception generally applies to workers who perform, quote, vital religious duties, unquote, to advance their organization's core mission. So vital religious duties are what the courts are looking for when considering whether an employee is a minister. So this gives us some guidelines. It doesn't completely answer the question of who is and is not a minister. We don't know the exact extent of who's covered, but we do know that it goes beyond ordained ministers. Right? Our Lady of Guadalupe makes it pretty clear that religious education teachers can be ministers. There was a recent case in the Fourth Circuit, I think that was 2023 now, called Billard, which seemed to signal that even teachers of secular subjects, even substitute or part-time teachers, if they're at religious schools, they may be ministers if they're expected to perform vital religious duties like praying with students, witnessing to the religious faith of the school, catechizing, counseling, etc. So here we are. We know that the ministerial exception exempts religious organizations from non-discrimination laws if the employees in question are ministers, but we're going to continue to watch courts apply that logic. And we just saw the Ninth Circuit apply just this doctrine of law in the World Vision case that recently came down. So World Vision, it's been going on for a while. The nonprofit, it's a Christian group called World Vision. They were recently sued for rescinding a job offer when the organization learned that a candidate was in a same-sex purported marriage. So the candidate was applying to be a customer service representative for the organization. And you can see here where the conflict or the question is going to come up. Right? Is a customer service representative a minister for purposes of the First Amendment? So according to the record in this case, World Vision's customer service representatives, they call donors to maintain relationships. They explain the nonprofit's programs like sponsorships for impoverished children, and so on. They also do some administrative duties. So the court here ruled that World Vision's customer service reps do qualify for the ministerial exception because the nonprofit labels them as the voice and the lifeblood of the organization. The judge who wrote the opinion, Judge Tallman, noted that while the role itself of a customer service rep includes many secular and administrative responsibilities, customer service reps also perform, here's the language, vital religious duties crucial to World Vision's mission by explaining World Vision's ministry, its programs, and by giving people an opportunity to join in the mission of God through donations and sponsorships. Right. So the Ninth Circuit here concludes that the nonprofit was not subject to the non-discrimination laws that would otherwise prevent it from making a hiring decision on the basis of the candidate's sexual identity in this case, or sexual orientation in this case. By ruling in favor of World Vision, the court shows that individuals in roles that may appear to lack many explicit religious duties can still qualify for the ministerial exception. So good ruling from the Ninth Circuit, and there are a couple of points that I want to highlight that are dear to the heart and the mission of Napa Legal. For one, this is an issue we've been watching at the organization for years, and I want to point something out. On one hand, it's really important that we continue to see courts apply the ministerial exception broadly. Right? Ideally, I'd like to see most, if not all, employees of religious organizations covered under the ministerial exception. And practically, there are steps that can and should be taken by religious organizations to promote this understanding of what a minister is and what the ministerial exception applies to. Religious organizations should take seriously the idea that all of their employees are, in fact, not just for purposes of, being covered by this law, but in fact are ministers. Right? It doesn't mean they're all ordained. It's not what we're talking about, as I said. But everyone from the receptionist to the janitor at a religious organization should participate in regular prayer together. They should receive religious formation. They should be ready to be a witness to all those who come through the organization's doors, right? That should be the ideal of a religious organization, because if you exist to fulfill a religious mission, everybody who works there should be part of that mission, right? Donor dollars are going to pay those staff members. Obviously, they're going to have secular and administrative jobs to do, but they should all be acting like ministers of the organization's work. So I want to be clear, we don't have a precedent, at least not yet, that the janitor and the receptionist, by participating in prayer and catechesis and all this, qualify for the ministerial exception. Although I would say the World Vision case gets us a little closer when we're talking about the receptionist, right? These customer service reps, they're not catechists. They're not on the ground doing works of mercy or evangelization. But as the court said, they're the voice and the lifeblood of the organization. I think you can argue that receptionists, right, people who answer the phones, people who answer emails, and so on behalf of a religious organization, are pretty key to the ministry of that organization. So we're not there yet. But it's a good practice, both legally and to more fully live out the religious mission of the organization, that all employees, as much as possible and proper to their roles, be trained and treated and expected to behave as ministers, as part of the organization's religious identity and mission. On the other hand, though, I think this is a good time to advertise, as I often do, for the importance of clear statutes, right? A broad ministerial exception doctrine, it's great. It's a good benefit for religious organizations who can more confidently hire, promote, fire employees based on their religious principles without worrying about being sued under secular non-discrimination laws, right? If you're a religious organization dedicated to doing a mission, you should be able to hire and fire and choose your employees based on who is going to help witness to that faith and accomplish the mission of the organization. If you have a strong, broad ministerial exception, that helps. But even a broad ministerial exception has to be proved in court, right? When a disgruntled employee is terminated, or they're not hired, or they're not promoted, then they file a lawsuit. The religious organization can win by raising the ministerial exception, right? The broader the exception, the better their odds in court. But ideally, we never get there. If states have broad exclusions or exemptions in their own non-discrimination statutes, making it clear that religious organizations are not covered by these laws, then religious organizations can be spared, right? The time, the resources, the stress of litigation, because the law is clear that non-discrimination statutes don't apply to religious employment practices in the first place. So there are two main ways that state law can do this, and then I'll turn it over to you, Joseph, and stop talking. The best two ways that we see this done are, you can either have broad exemptions, right, where there's a law, it applies to employers, but then you have a provision that says, well, if you're a religious organization or an organization that hires employees, but you're operated primarily for religious purposes, then certain non-discrimination statutes don't apply to you, right? The ones we're particularly looking at are sex, sexual orientation, gender identity, and religious discrimination, because those sexual orientation, gender identity categories often conflict with religious worldviews, and non-discrimination on the basis of religion or religious belief doesn't really make sense for a religious organization, because while you might want the local bank not to be able to say, no Muslims or no atheists may apply, right? That might be bad civic practice. But for a religious organization, of course, there should be room for just that, that a Catholic school doesn't need to be required by law and should not be required by law to hire Muslims or atheists or whatever group of people don't agree with the essential religious teachings of that organization. So those kind of exemptions, exempting religious orgs from certain non-discrimination laws are helpful. You can also see these in the form of broad exclusion, which some states have, and that's better, or it's at least broader and clearer what's going on. And what that will generally look like is you'll have a non-discrimination statute, and it will define employer and say, right, an employer is any company or group or individual that hires maybe at least 3 employees, or just that hires employees, period. And then the definition of employer can explicitly say a religious nonprofit organization operated for religious purposes is not an employer for purposes of this non-discrimination statute. And then you're safe. So again, this is a great application and potential expansion of the doctrine of the ministerial exception. It's great to see a world in which more and more religious organization employees are not considered secular employees, but are considered ministers for purposes of the First Amendment. And as always, we would rather have clear statutes so that religious organizations don't have to go to court and determine that they do in fact have these rights. So, Joseph, any thoughts on World Vision?
Yeah, I'd love to add a bit to your last point about the importance of state laws in this sort of thing, and kind of clarify the current landscape of this at the state level, because this is a place where there's a lot of room for improvement. Like you mentioned, how there's exemptions or exclusions. Right now, only about 12, 13 states have really strong versions of those exclusions or exemptions. After that, there's kind of a cascade of a large number of states that have some weaker, some strong exemptions. For example, some states allow religious nonprofits to hire only co-religionists. Some limit that kind of more narrowly to only hiring or to only being exempted from these non-discrimination laws for individuals and roles that carry out religious functions themselves. So a handful even have no exemptions, effectively no exemption. So this is a place where there's a lot of room for growth in the state law. And these sorts of cases with World Vision, they're all over the place. There are plenty of examples we can bring up. Right now, there's one at the circuit level. It's a Zinsky v. Liberty University in Virginia, where basically this individual got a job at Liberty University. They're a non-denominational Christian college in Virginia. And at the time said, yeah, I'll abide by kind of your vision of sexual orientation and gender identity. All that's great. Signed the statement of belief and everything. And then after this person's probationary period ended, they revealed, oh, I've been on these quote unquote sex change hormones for the past several months. It somehow came up in one of the conversations. And that this individual then be identifying by the opposite sex. In result, Liberty University was upset and I think tried to terminate Zinsky. And right now they're in hot water over that, about whether or not they're allowed to actually do that. So I don't think the ministerial exemption ever came up in that case, but it's just one of those many examples where these exemptions for faith-based nonprofits are so important, because you can't really say a Christian school is Christian if they're not allowed to have Christian staff, or the same for is a pro-life center really pro-life if they are forced to hire people that are pro-abortion. So it's so important to the basic identity of these religious organizations to have the freedom to make their own hiring decisions. Great. So with that, we'll move into our second update for the week. Also good news, also in Colorado, following the trend of the last couple episodes. So a federal district court in Colorado ruled earlier this month that a Catholic medical care center can continue to provide abortion reversals. So just there's a lot of terms and definitions with abortion pill reversal. So I'll give a little bit of a breakdown on how these things actually work, just to get the terms defined. So an abortion pill is a 2-part medication. Basically, when somebody seeks out to have an abortion chemically, first they take this drug mifepristone, and then after some time, they take a different one, misoprostol, and they both do different things. Reversals can be done in between these 2 steps. So after somebody takes mifepristone, if they decide this was a mistake, I don't want to go through with this, there's a chance, at least, of this time window whether they can take this drug that will counteract it, and prevent the child from being aborted. So mifepristone basically interferes with this other hormone called progesterone. It binds with these cellular receptors that progesterone is meant to bind with, and makes it so that they can't. So basically, in blocking out progesterone, it cuts off oxygen and other nutrients from reaching the baby. Now, the way these reversals work is after somebody's taken mifepristone, they're given basically a supplement of progesterone to try to flood out the mifepristone, and combat it in their system. So if there's enough progesterone, the thought is that there's a chance it could still kind of bind to the receptors it needs to, and it won't be flushed out by the mifepristone. The kind of controversy here is that this is an off-label use of the hormone progesterone. There are lots of off-label uses that are very much supported by state law that we'll get into in a little bit. But that's kind of one of the things that comes up here. And there's some debate over how effective it is. But again, as we'll get to very shortly, this medical provider has a lot of really good experiences and has seen a lot of success stories in using progesterone to counteract the effect of an abortion pill. So moving into this dispute itself, it's over this group called Bella Health. They're a major Catholic medical clinic in Colorado. They've been around for about a decade, and they have 24 or so practitioners. It says they have 28,000 registered patients, so they're a pretty big organization. And they're Catholic kind of through and through throughout all their practices and documents. So as a result of that religious identity, they see abortion pill reversal as a moral obligation. And several times a year, they're able to carry out this successfully. In the case document, it noted that just since the case has been pending, 11 healthy babies have been born after their mother ingested mifepristone and then ingested the abortion pill reversal. So Colorado amended their Consumer Protection Act to define using progesterone to counteract the abortion pill as professional misconduct. So basically, any nurse or doctor that prescribes this for this particular use could lose their license or be subject to other disciplinary action. So at the day that this amendment was signed, Bella Health filed a lawsuit basically for an injunction to not have this law enforced against them. And this month, the district court ruled in their favor. Basically, the court ruled that the law that made this professional misconduct is not neutral or generally applicable. Therefore, it's subject to strict scrutiny, which it fails. So for the neutral and not generally applicable portion, basically state law permits any other off-label use of progesterone aside from abortion pill reversal. And that abortion pill reversal is a necessary exercise of Bella Health's religion. So some examples for using progesterone off-label, some of them are really good. There's this other fetal disease called luteal phase deficiency that that progesterone can counteract, other preventing miscarriages and other very legitimate reproductive health conditions. All those are perfectly protected with state law. There's no problems with that. And even actually, it's sometimes used for quote unquote gender affirming care. I'm not sure the exact way it is, but basically progesterone is used for lots of things. And the only thing that's being outlawed is abortion pill reversal. And that's why it's not neutral or gender applicable, because it's targeting this one religious exercise. And because of that, because of the 1990 Smith, the 90 Smith decision, it's subject to strict scrutiny, which it also fails to pass. The main reason there is there's no compelling interest to prohibit only this religious exercise. The kind of claim from the Colorado government says that they ban it to protect the health of mother and unborn children. Again, there's a very good track record of using progesterone, so that on its own is pretty scientifically questionable. But legally, that's clearly false. Because the drug itself is unregulated for lots of other uses, including gender affirming care. And it's also not narrowly tailored because there are lots of other ways you could carry out that, just as simple as an informed consent requirement, which is usually necessary in the first place. So this is limited just to this case. So Bella Health themselves are now allowed to continue prescribing these abortion pill reversals without facing penalty. So Frank, I'll hand it off to you for your additions.
Yeah, no, that's a good overview. So it's worth pointing out for the legal practitioners here that the media has talked about the court blocking these laws. So like you said, this is a district court case, so it's not precedential. It applies to Bella Health and any parties acting in concert with them, but it's also not a temporary, like a preliminary injunction or a stay of the law. This is a summary judgment. So this is the end of this case. It is final that this cannot be applied against Bella Health. Hopefully we'll see what happens. I mean, Colorado may just stop enforcing it, or we may see repeats until we find this going up to an appellate court, so we get some binding precedent on it. But I mean, I think it's pretty clear, and like you said, Joseph, they give away the game because they're not. It would be one thing if the Consumer Protection Act or the medical powers that be in Colorado just banned progesterone as an unsafe supplement or prescription, but that's obviously not the case, and there's no evidence that it's dangerous. I mean, as you know, I have 5 kids, and I know quite a bit about progesterone. It is the side effects of it are so low that you can actually get certain forms of it over the counter, like admittedly weaker forms and creams and things like that. But low progesterone, like you said, it's thought to be a common cause of miscarriage. So actually just supplementing progesterone when women are not pregnant but hoping to get pregnant, or newly pregnant and have a history of miscarriage or low progesterone levels. This is very common practice, and there are really no serious side effects. I don't want to say no side effects. I'm not a doctor, but I know it's prescribed fairly freely. I know you can get it over the counter. And like I said, you're giving away the game when you can say like any off-label use of progesterone, including just treating like luteal phase progesterone deficiency, when that's okay, but somehow using it to reverse abortion pills is is the only way time in which that it's prohibited. It's clearly not a neutral law, like you said, because you're not going after the safety of this drug. You're going after a particular pro-life use of it, and that's not general, that's not neutral. That only applies to pro-life clinics. So that's a huge problem. Good to see. This happened. If anybody's, this is jogging your memory, Bella Health was in the news over this case in 2022, 23, because in the initial phases there were administrative blocks to using progesterone. There was this thing that there was some potential for medical professionals to be subject to discipline if they used progesterone in any way that was not signed off on by a couple of Colorado boards and agencies. And Bella Health got in a fight, and I think it was settled. But then when this consumer protection law was amended to double down on banning progesterone as abortion pill reversal, we got round 2 here. So the only thing I would say to wrap up here is, for one, it'll be interesting to see what Colorado does if they decide. I don't imagine they'll repeal the law if they have an executive decision not to enforce it, or if they're going to go full steam ahead and keep doing it and try to get another case in front of a different judge and look for a different outcome, at which case we would definitely see an appeal. Remains to be seen. This is a victory for Bella Health, not for the greater law in Colorado, unfortunately. So time will tell what this does, but I think it's always really important to see these things just fought aggressively from the beginning, because it's so easy to couch laws and, oh, it's neutral, it applies to everyone. We're not talking about pro-lifers, we're talking about anyone. This is a deceptive practice, dangerous practice. For one, it's obviously not. But for two, you're hiding it in neutral language, but you're going after one particular use and one particular viewpoint here. Because the only way that you could say, well, this is a consumer protection practice that's legitimate, would be if Bella Health was going around saying, you take this pill and it will reverse abortion pills 100% of the time, no matter what, if they were making a false or misleading statement. But it doesn't seem like they are, right? The record here and Bella Health's own materials are pretty clear that it doesn't always work, but it clearly works. We have a lot of anecdotal evidence. Like you said, Joseph, they have, 11 instances where they can document that someone took the first stage of the abortion pill, took progesterone, and the baby was carried through to term. So clearly they're not advertising miracles. What they're advertising is based on their own practice and on the evidence they've seen that this can sometimes work. And if it doesn't work, it's not harmful. So to me, it's pretty clear that Colorado doesn't have a leg to stand on to say that this is anything other than anti-pro-lifer discrimination is kind of a farce. All right, well, let's do one more piece of good news to wrap up here for the pro-life community in particular. So we'll go to the state of Oklahoma, which has really been on fire. If anybody's been following our podcast or our weekly, Oklahoma, it's not just a series of like separate bits of good news. Coincidentally, Governor Kevin Stitt is really leading the charge to aggressively use his lawful authority as governor to make Oklahoma a state where life is respected and religious freedom is robust. We covered a couple months ago his executive order that he was requiring that his agencies not enforce several state laws that he thought were unconstitutional under the First Amendment, which was awesome. And then he also suggested, I think, a half a dozen laws that the legislature in Oklahoma should take a look at because he thinks they're clearly unconstitutional under the Free Exercise Clause. So Governor Stitt is a trailblazer and is really doing good work. So there was a recent executive order on the abortion issue that was issued. I just want to get the date. It was very recent. July 31st. And what this one does, it's if you're familiar with Planned Parenthood v. Medina that the Supreme Court recently released this past term, this will sound familiar. Governor Stitt directs all state agencies in Oklahoma to cease providing any state or local funds to any organization that performs or facilitates the obtaining of, which I think would mean refers for abortions. The order directs the Oklahoma Healthcare Authority to initiate a review of its provider credentialing requirements to ensure that no organizations involved in abortion are eligible for the state's Medicaid program. And again, this comes in the aftermath of Medina, which clarified that states can, in fact, prevent abortion providers from receiving public funds, even for non-abortion services. Right. So on one hand, I think first glance, people might say, oh, this is kind of performative. Right, abortion is already almost entirely illegal in Oklahoma. There are some exceptions when the life of the mother is in danger, but for the most part, there are not abortions in Oklahoma. Well, I'll caveat that in this world of mail order abortion pills, I'm sure there are abortions taking place in Oklahoma, but they have to be procured from out-of-state providers because Oklahoma does not, in fact, allow abortions in almost all cases. So that being said, yes, Oklahoma has almost completely banned abortion within the state. But on the other hand, I think it's worth watching how broadly this policy will be interpreted and applied because it can still have more than symbolic anti-abortion effects in the state and in fact beyond, right? So I think the key language in the executive order is that it blocks funding to, quote, any individual or entity directly affiliated with a physician, a medical practice, or another organization providing abortion services or facilitating the procurement of abortion services, period, end quote. So what you'll notice is it doesn't say it blocks funding to any individual or organization that provides or refers for abortions in the state of Oklahoma, but at all. So I think there are two relevant situations here that I just wanted to highlight because I don't know if this will be clear as the media starts reporting on this. Is for one, anyone familiar with healthcare law knows that we don't have mom and pop doctors and local independent hospitals the way that we used to. We have massive networks, and a lot of them serve across state lines, right? So I don't know the situation with hospital networks in Oklahoma, but if in theory a hospital network has clinics or hospitals in Oklahoma as well as other states, I think the way I read the executive order, if that network provides abortions across the border in another state, but not in Oklahoma because of the law, I still think that their Oklahoma practice is probably going to be banned from receiving state and local funding under this executive order from Oklahoma's government. So that's one thing to watch. Also, I did a quick Google search before I got on here. Even though abortion is largely banned in Oklahoma, Planned Parenthood does have, I found at least 3 clinics on Google in the state of Oklahoma. So it's funny, if you look on there, Google has this like disclaimer that says, note these locations might not provide abortions. They likely don't. But they offer whatever contraception and exams and other things in the state of Oklahoma. Again, the way I read this executive order is not a dollar goes there, even though those Planned Parenthoods don't provide abortions in Oklahoma. They're part of an entity that does in fact provide abortions. And so I think under the executive order, those Planned Parenthoods are not going to receive any government funding. So I think for one, I don't think this is merely symbolic. I think it'll have some effects. It'll at least take state funding away from those Planned Parenthood clinics, even though they don't provide abortions. But also, I think this is about more than defunding abortion directly. It's about more generally defunding organizations that participate in abortions at all, even when they provide other medical services. This sends a message and also takes action to say, listen, as Christians, as people of faith, as just people in favor of human rights, abortion is a travesty, right? We shouldn't be, not only should we not be killing unborn children, but we shouldn't be funding any organization that's even involved in this practice. So this is a pretty broad stroke from the governor of Oklahoma. Glad to see them continuing to be a bold and creative example of a pro-life, pro-religious liberty state. So Joseph, anything to add before we close out here?
Yeah, I just want to zoom in on the one point you made and add some notes about the potential impact of how Oklahoma preventing funding for networks and potentially misnamed providers because not providing anything good that perform abortions in other states, specifically with Planned Parenthood. So, as probably most of our listeners know at this point, Planned Parenthood has had a lot of facilities closing in the last few years, per a report from the American Life League I was reading through, which is very encouraging. In the last 4 years alone, 66 facilities have closed for Planned Parenthood permanently. They've opened 20, but that's a pretty big drop in just 4 years. In just 2025, from January through May, 24 closed. And as of May, there were only 509 total facilities. So a significant portion of these major abortion providers are closing their doors. Last month, actually, what was the largest abortion provider at one point in the world closed down, and it was in Houston. Um, so, from my understanding, that's largely a problem of funding. Again, as our listeners probably know, there's a dispute right now about the federal defunding of Planned Parenthood through the Big Beautiful Bill, and it's working its way through its courts right now. But regardless, seeing this at the state level is really encouraging. We still have to kind of see what the application actually looks like, and if if providers that don't provide abortion within the state are still defunded if they provide abortions in other states. We have to see how it plays out. But if other states adopt similar policies, that really cuts the leg out from a lot of major abortion providers. So it's great to see these steps starting to be taken at the state level.
Great. Well, like I said, good news today. Good win for the ministerial exception, good win for Bella Health, and another good win in Oklahoma. And I think on that cheery note, well, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content that we put out, we always appreciate if you like this podcast and subscribe to our channel on YouTube, Spotify, wherever you're listening from. If you want to support the work we do, we could always use your contributions. You can visit Napa Legal's website and donate to help us to continue to do the work that we do. We hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. With that, we'll talk to you next week. Thanks for joining us, and God bless you.